Now, Mr. Terwilliger, in the events leading up to the Civil War, the Confederate States asserted a power of nullification, supremacy over the federal government, that ultimately was resolved at Appomattox Courthouse. But I am unaware of any assertion by the Confederate States that they could, say, seize Abraham Lincoln and try him in their state courts. Is there any precedent in the entire history of our country of what the Biden administration and its partisans in New York and Atlanta attempted to do?
Not that I'm aware of, Mr. McClintock. In fact, privately and to others perhaps in the president's circle, I described the command that Mr. Trump be in Judge Merchan's courtroom when he was already a declared candidate and ready to campaign, that he was truly America's first political prisoner. That case needs to be able to be removed from federal court, to federal court rather. I mean, suppose some state authority had decided that Joe Biden was not of sound mind and was a danger to himself or others, including the country, and decided to civilly commit him under state law. Do we think that case ought to have stayed in state court? Of course not. This is a very important step. And if I may just take the opportunity, because I think this is so important, Professor Besky is exactly right about the Mesa decision, which her Justice O'Connor, wrote. And it's why I think that when the committee marks this bill up, you ought to just simply incorporate federal question jurisdiction into the basis for removal, because all of these removal cases involve federal questions, such as what is the scope of the duties of the federal officer. We don't want those decided in state courts.